my name is Miss Kimberly. I'll be your substitute teacher today. We're going to talk about how to critically evaluate how fair the jury decision-making process looks like. But before that, let's take attendance. Rishima?
Here.
Beck Shuang Li?
Yeah.
Crystal?
Yeah.
Siba?
Here.
Before we dive into these questions, I'm going to give you a brief introduction to what the decision-making process looks like. The jury decision-making process starts from when they enter the jury room. This is where the deliberation begins, where they discuss the case by carefully considering the evidence presented in the court by the witnesses, the arguments of the defense and prosecution, and the summing up of the judge. No outside communication is allowed except to jury keepers, and any misconduct will be fined. During the deliberation, members of the jury will discuss amongst themselves their thoughts and justifications to why they feel as such. Though precautionary measures do exist, if the juries encounter any problems, they can contact the judge through the jury keeper for guidance. However, the jury will still have full autonomy over their decisions. The verdict also remains final. Their decision is of utmost importance as their verdict decides the future of the defendant and how that looks like. Considering the stakes are very high, it's important to ensure that the jury system is one that is the fairest and most reasonable in all circumstances. That is why it is important for us to evaluate how fair the process looks like through answering these three questions.
Section 8, subsection 1 of the Contempt of Court Act 1981 prevents direct investigation of jury deliberations, and so conducting actual research about the racial stereotyping among jurors is impossible. Thus, the main sources of statistics available are the various studies conducted in the area. In a survey conducted at Blackfriars Crown Court, London, 27 separate juries with 319 jurors were included. It was a study of racially mixed juries and so enabled to draw direct comparison between the decisions of white and ethnic minority jurors. The result of the survey showed that even though the defendant's race did not have an impact on the jury verdicts, because members of different ethnicities were in the jury, race did have a significant impact on the individual votes of some people who sat on these juries. To summarize these findings, the statistical analysis of the individual votes showed that white and black and other ethnic minority jurors alike were significantly less likely to vote to convict a defendant of their own race.
It is not necessarily true that juries are partial towards different races intentionally. These decisions can be easily influenced by their moral values, personal experiences, personality, beliefs, and many other factors like this. Dangerous but very common prejudices among people in general are that black people are inclined to aggression and they do not respect the law. Asians are devious liars, Muslims are terrorists or terrorist sympathizers, and the Jews are greedy. These are only a few general beliefs engraved into the Western minds, and so jurors who come from the same backgrounds might intentionally or unintentionally be biased towards such parties. This problem could be solved by a composition of racially mixed jurors for a case. However, in R. Ford, when a defendant who was of mixed race applied for a multiracial jury, this was refused by the judge on the basis that he had no power to do so. This is as true as under Section 3 of the Juries Act 1974. Juries are supposed to be selected randomly and not picked on a specific basis.
There have been many cases which have shown that jurors have been racially stereotypical toward the defendant. For example, in case Keith and Stella, the jurors have been racial biased towards the defendant in giving the death sentence.
Hi sir, why do you think the appellant is guilty?
I think that the appellant is guilty because black people have no souls. They did all the bad things and they are either black folks or the N-words. I believe that the appellant is the later one, and so I vote for the death penalty. Thank you.
Even though the appellant deserves no sympathy, it is doubtful that his trial is free from racial bias. Hence, the US Supreme Court had decided to put the execution on hold for further investigation.
In Gregory and UK, a black defendant was convicted of robbery upon a majority verdict. During the trial, almost 2 hours after retiring to consider its verdict, a note was passed to the judge from the jury stating that one juror was racially biased and needed to be excused. Despite this, after showing the note to the prosecution and defense, the judge only issued a redirection to the jury to consider the case based on evidence alone and continued the trial. Mr. Gregory was sentenced to 6 years imprisonment. It was applied to the European Court of Human Rights that his rights to a fair trial, guaranteed by the ECHR 1950, Article 6, Section 1, had been infringed. This application was dismissed by the ECHR as bias among the jury was not proven. It was held that the judge had issued the direction after consulting both counsel and his warning was very clear.
Similarly, in Sander in UK in 2001, an Asian was convicted of conspiracy to defraud. The trial was discontinued following a complaint by a juror of racist comments from 2 other jury members. The following day, the judge received 2 letters, one from a juror apologizing for his conduct and assuring that there was no racial bias from his side. The other was a collective letter from the jury refusing all allegations of racial bias. Just like in Gregorian UK, the judge redirected the jury but chose not to discharge them. After being unsuccessful in his appeal to the Court of Appeal, Sander then applied to ECHR complaining about his right to a fair trial. The ECHR held in Sander's favor and highlighted a number of issues with this case.
In R. and Mirza, the defendant was an Asian who was settled in England for a number of years. His first language was not English and therefore was provided an interpreter throughout his trial on charges of indecent assault. The jury sent 2 notes to the judge during the trial questioning the use of the interpreter. Despite being warned against drawing an adverse conclusion from such use, a letter came from a juror saying that the other jurors were prejudiced against the defendant on racial grounds and as a result had been entirely impartial. The defendant appealed on the basis of the Article 6 of the European Convention on Human Rights. The majority of the House of Lords held that Section 8 of the Contempt of Court Act 1981 did not breach Article 6 of the ECHR as it was addressed to the third parties and not the court itself, and that the courts can and should carry out investigations of the allegations of jurors' misconduct to the extent permissible under the general common law rule protecting their privacy.
Supposedly, there are several safeguards to ensure that the jurors are impartial and stay neutral towards the defendant from various race. For example, the jurors have taken an oath to be impartial before the trial. The challenges against the juror before they are sworn in to become a qualified juror. The decisions are made based on majority verdict, the deliberation of the judge to dismiss the juror, and the ability of the defendant to appeal.
We'll keep on appealing to the Supreme Court!
However, the existence of the safeguard is not even remotely close to eliminate the threat of racial stereotyping among the jurors. This is because the court had presumed that juries will act in the manner of a model juror and refuse to make any proper investigation on the allegation on particular jurors which fail to behave in accordance with the ideals. Secondly, the preemptory challenge which allowed the removal of juror had been abolished in 1989, making the impartiality of jurors never assured. Furthermore, the confidentiality revolving around the jurors' deliberations have created more difficulties, making the investigation of bias become harder.
Thus, it can be said that even though the Article 6 of the European Convention on Human Rights, which guarantees the right to a fair trial, incorporated into the English law by the Human Rights Act 1998, and this is applicable to both professionals and lay tribunals, a jury trial doesn't necessarily live up to this level of impartiality. Unarguably, there is racial stereotyping among jurors to an extent.
Jurors searching on the internet for the information on the accused have been heavily criticized by the Attorney General in a recent speech. Trial by Google threatens the integrity of British jury system and affects the principle of open justice. This has shown that the juror use of the internet research tool and social media has affected justice. This is because, in most of the time, The resources on the internet is already with an opinion on the case, and this affect the state of mind of the juror and make them hard to form personal opinion.
According to a study carried out in USA, jurors like to use the internet to do research on the cases that they assign. The growing number of media stories about jurors' improper use of internet and social media made it clear to some judges that the language line in the earlier cautionary instructions did not convey the intended meaning to jurors. In recent times, information about trials can be shared via any form of social media, interfering the right to a fair trial. Traditionally, courts have sought to balance a number of potentially conflicting rights and principles when governing trials. Social media use by jurors can damage the capacity of courts to maintain and balance an appropriate level between these rights and principles.
There are three main ways that the jurors may use social media inappropriately. Firstly, they can publish or distribute information about the trial. Then, they can learn information about a case from a source outside the court. Then, they could also contact other parties or witnesses and sometimes even lawyers to discuss the merits of the case and even at times to seek for opinions. Due to this, the defendant's right to a fair trial will be at stake. He or she will even start to lose control of the confidence towards the administration of justice. The introduction of external material into jury deliberation increases the risk that the jury may be influenced by information which are detrimental, unreliable, and/or inaccurate, and sometimes even information which is ruled as inadmissible in court. Many problems can arise with juries looking into social media. For example, in the case of A.G. and Frail, Joanne Frail was sentenced to 8 months in prison for contempt of court for exchanging Facebook messages with an accused in a drug trial while she was serving as a jury. She also searched online for information about another defendant while she and other jurors were still deliberating. Another problem with jurors using social media is they disclose information while ongoing trials.
The Massachusetts Appeal Court refused to set aside the conviction because of overwhelming evidence of the guilt of the accused. However, the case illustrates the difficulties courts face attempting to regulate the formation of friendship in the jury room via social media. In other circumstances, jurors using social media to seek responses about the case. A UK juror was dismissed from a child abduction and sexual assault trial after she asked her Facebook friend to help her decide on the verdict, in which she wrote, "I don't know which way to go, so I'm holding a poll." This was discovered prior to the jury starting its deliberations. The trial continued in her absence. Even where the information is reliable, jurors should not base their verdict on information that has not been subject to scrutiny by both the prosecution and defense in court. Jurors must base their verdict upon the evidence they have heard in court. In R.N. Karakaya, the defendant was charged with rape and of indecent assault of his daughter. A juror in this case carried out research online into rape and took material found on the internet into the jury room.
An assessment has been called out by the Court of Appeal in Thompson on how best to ensure the collective responsibility of jurors in the operation of jury trials. In this research, the juror was being examined on 6 different types of improper conduct scenarios and what they will do when that occurred. The scenarios include the juror being approached by someone outside the court who is connected to the case, being aware that the other juror has been approached, discovering that a fellow juror had found information about the case not presented in the trial, seeing a fellow juror using a mobile phone during the trial, being pressured into reaching a verdict, and jury deliberations.
When someone involved in the case tries to speak or contact the juror personally, and if they saw someone associated with the case speaking to a fellow juror, the jurors would do what they need to do, which is inform the jury manager, usher, or the judge. Jurors are less likely to report instances of fellow jurors finding information out about a defendant that is not disclosed in the trial, or when a juror uses a mobile phone in court during the trial, or when there are different types of pressure exerted on the jurors during deliberations. There are two scenarios where the highest proportion of jurors said that they would not feel comfortable doing anything at all related to contempt and new media. If a juror introduced additional information into deliberation that had not been presented in the trial, 14% of them said that they would not do anything about it because they did not feel comfortable doing so. If a juror used a mobile phone in court, 10% of them stated that they would not feel comfortable reporting it.
When it comes to inappropriate conduct of fellow jurors to each other in the deliberation room, it was held that the juror is more preferred to settle this themselves by speaking directly to the juror which may act inappropriately. 39% of the jurors held that they will speak directly to the juror which have unduly pressuring the another juror to reach a verdict. If one juror was not giving the another juror the chance to express their view about the case, 46% of the jurors held that they will deal with this internally and speak to the juror concerned. This present substantive evidence has shown that a better instruction is needed to be given to the juror so that they know what, how and when to report the concerns to the court.
However, it is also important to emphasize one consistent finding in this part of the study, regardless of the scenarios involved. The result clearly shows that 2 points of contact for juries are crucial in preventing juror contempt and ensuring that any evidence of improper conduct is brought to the court's attention. Ushers and jury managers, not judges, are the court officials jurors feel most comfortable reporting any concerns to about improper conduct. In all 6 scenarios, it was the jury managers and ushers that the overwhelming majority of jurors said that they would go to if they were going to report anything they felt might be wrong. This finding has been important implications for staffing in the Crown Court and highlights the need to ensure that these positions are properly staffed, resourced and trained in all Crown Courts in England and Wales.
Levels of jury tampering were reported in 2002 to be a major problem by the Deputy Commissioner of the London Metropolitan Police, and in 2003 to be worryingly high in Merseyside by the then Chief Constable Norman Batterson and the Home Secretary David Blunkett. Jury tampering is a crime that involves attempting or influencing a jury and the decision-making process through other means than the sole evidences that are presented during a trial. For instance, offering bribes, making threats, or even having conversations about the case outside the court. A person is not supposed to communicate with the juror regarding anything related to the substance of a case. Also, courts do not want any outside information or personal opinion about a case to support the analysis of jurors because it is considered potentially unreliable. If juror tampering or misconduct is found or heard by the court, the judge will determine how likely the influence will influence the juror's verdict or before granting the defendant a new trial. However, it is not easy to prove a juror being illegally to prove that jurors are subject to these crimes.
Police forces are having to spend millions of pounds a year protecting jurors from threats and bribes as cases of jury tampering soars. The Metropolitan Police alone has been paying out an average of £4.5 million a year on protecting juries, especially those sitting in the criminal cases at the Old Bailey. There have been complaints of jury tampering during high-profile cases. These includes 2 jurors in the case of Tony Martin, the farmer who was jailed for the manslaughter of a burglar, Fred Barras. In the letters of the Court of Appeal, the pair said that they felt intimidated by friends of Barras and afraid during the trial. Another case is about a former police sergeant who was decorated for bravery, became the first officer to be convicted of jury nobbling. John Young was jailed 7 years after he was convicted of offering the names and addresses of jurors for £30,000 to the sister of an armed robber.
For issues of when and under what circumstances a trial judge may order for a continuation of a trial without a jury is pursuant to Section 46 of Criminal Justice Act 2003. The Act is one of the bundle of sections which deal with jury tampering. Section 44 of the Act deals with cases where there is evidence on real and present danger that jury tampering might take place if the jury trial is conducted, empowering the prosecutions for such cases to apply for a trial without jury. While Section 45 of the Act deals with the procedure that need to be followed if Section 44 is applied. Furthermore, in the case R.M. McManamam is one of the significant additions to the case law in interpreting the provisions.
In RMT case, approaches were being made to two members of the jury, which prompted the trial judge to conclude that there had been jury tampering and the jury was discharged. The well-known American defense lawyer was charged with jury tampering in 1911. At his trial, in which he was ultimately acquitted, it was alleged that he had acted as defense counsel in U.S. and Rutherford, which is a case in U.S. It was also held by the courts that the facts of the government agents glaring at jurors during a criminal prosecution could amount to jury tampering. Furthermore, a jury foreman named George Pape in a trial of John Gotti sought out Gotti's underlings, who agreed to pay £75,000 in exchange for a non-guilty vote. Pape was then convicted of jury tampering and sentenced to 3 years of imprisonment.
It's hard for us to ascertain if the process is the fairest and most reasonable conduct. To break this deadlock, we must look at exclusive advantages the jury has and why no other alternative is suitable. Amongst many advantages, I'm going to talk about two specific advantages. The first is on how juries are impartial and will make judgments based upon conscience and opinions. I know this signposting seems a little negative, but as I walk you through it, it'll make more sense. When jurors weigh up all the evidences and statements from witnesses and defenses claimed by the defendant, it's important to approach the verdict with a reasonable mindset, whereby the analysis on whether an average reasonable person would have possibly done the same in such circumstance. Sometimes decisions must be made on what seems right and not whether the offense is illegal or not. By this, I mean if the defendant acted in good heart and can convince the jury that his or her actions were reasonable in the circumstances, then the jury is able to acquit the defendant. A judge can only administer a verdict based upon facts laid before him, whereas a jury can decide based upon opinion. This has been evident in the case of R.M. Ponting in 1985. In this case, official secrets were disclosed. However, Ponting successfully argued that the secrets were disclosed in the interest of the nation, and he was acquitted by the jury. A further example was R. and Crowley in 1996. In this case, Cronlid and others caused 1.5 million worth of damage to a fighter aircraft that was to be sold to the Indonesian government. Cronlid successfully argued that the plane would have been used to tyrannize the people of East Timor and was acquitted by the jury. The comparison, however, would have been a judge analyzing the actions and the thought process of the defendant, in contrast with his or her own mindset. This may possibly be unfair due to the different levels of understanding in regards to the law. The judge may put unrealistic standards upon a person, for example, expecting them to predict the exact legal consequence and to act accordingly. Expecting individuals to understand legal jargons like mens rea or actus reus, these are unreasonable standards. These are probably very inaccessible for an average reasonable person, and it's unfair to assume that the person would have had the opportunity. In conclusion, with 12 jurors, a wide variety of opinions and input is accumulated together in the final decision versus a single judge viewpoint that is purely of the legal perspective. The second advantage ensures sufficient check and balance when deciding the verdict. Within any system, bias and abuse of power may occur. Though it can be completely overcome, we must ensure that proper preventive measures are enforced. Amongst many checks and balances, they are present within the court structures. The jury remains a very crucial part as it comprises of 12 people. This prevents or makes it very difficult for the acts of bribery and manipulation to occur by virtue of quantity. It's easier to convince one person over 12 people. Realistically, this looks like having to approach multiple different individuals that live in different parts of society and having to convince them and ensure they do not rat you out or report you. This is really risky and very doubtful. This also establishes deterrence as the possibility of getting caught is fairly high. In the case of R and F in 2009, 2 members of the jury were seen talking to a law student who had been watching the trial. The convictions were squashed on appeal because of the appearance of a risk that the jury could have been influenced by the evidence not heard in court but by an outsider. In conclusion, it's simple and easier to ensure no influence from unauthorized parties occur. After the discussion we've had, how do you all feel about the decision-making process the juries have?
The jury system itself is fair, but just the individual involved in the system is unfair because of their personalities and their beliefs.
Yeah, that means that there should be actually more checks and balances in the jury system to ensure that the jurors that are selected are fair and just in what they do.
And I think the jury system allows the layman individuals to be more actively participated in the system, which makes it more accessible and relatable to the public.
So in conclusion, we recognize the fault in the jury system, but it is a critical part in the legal framework.